Well, hello, everybody. This is another edition of Zoom Landlord-Tenant Talk Radio every Saturday at 3 p.m. So glad that all of you guys can join us. I thought I was going to be in Mexico, but things didn't happen. So you got me again for another week. And we'll be doing this again next week as well. I do appreciate the fact that so many people are joining and either listening on the Zoom or on YouTube Live. I would ask that if you do listen to it on YouTube, even because I'm going to make a recording of this, please subscribe because it does help defray some of the costs. And I'll keep coming at you with all the strength I have week to week. I always open it up with a topic. So the topic today is going to revisit something that I talked about last week, which was the city of Los Angeles. And right now we have the ability to start evictions or start civil lawsuits for all rent owed during the COVID period. Right now, as of February 1st, it's all open. So we can start evictions based on old COVID rent, or we can bring forth eviction lawsuits. Now, I talked about it briefly last week, and the law changed on us as we were speaking. In fact, one gentleman in our Zoom podcast told me that the county of Los Angeles was enjoined dealing with the requirement of doing a 30-day notice. I hadn't heard it, and that's why this is such a valuable community that we have here, that we even though I'm involved in the laws, these laws are changing as much as they possibly can. So I am going to show you a chart right now. Let's take a look here. I'm going to share this screen with you. And so I just want to go over this once again because I didn't want to have a situation where people don't know what they're doing. So for the city of Los Angeles, if we look at this chart, and maybe I can even make it a little bigger for you guys. Let's see, that's probably better. If rent was owed from March 1st, 2020 through September 30th, 2021, we can serve on that tenant a 15-day notice to pay rent or quit and proceed forward with a standard eviction. You can also, of course, sue in small claims court, where now for COVID rent, it's unlimited jurisdiction. You're not limited to $10,000. However, you do need to serve a 15-day notice for that period in time. Once again, that's from, if you can see where my pointer is, from March 1st, 2020 through September 30th, 2021. It is a 15-day notice. Now, though, if any rent is owed, let's move down on this chart here, from October 1st, 2021 through January 31st, 2023, that became due on February 1st, 2 days ago. So on that basis, we now can start evictions for that rent. And we've been taking them in a lot in the last day, because yesterday was the first day we could do it, where they owed it on February 1st and it became delinquent on February 2nd. So we've been serving 3-day notices because the county got enjoined, thank God. 3-day notice for the rent. And I'll tell you, these 3-day notices they're asking for, even though the rent's $1,500 or $2,000, we're asking for $35,000 in these 3-day notices, or $25,000, because there's so many months that these tenants chose not to pay the rent. And quite frankly, as we all know, that 95% of them were really not being honest about this, and really they were not impacted by COVID. And of course, we know that because we saw our tenants getting brand new cars and also going on vacations, etc. So again, if any rent is owed for this period of time, look at that chart and we can assist you. Now, if the period the amount of rent is for both periods, then we're going to need to serve one 15-day notice. But if it's just from, again, October 1st, 2021 through January 31st, 2023, we can just serve a 3-day notice and move them out. I'm going to stop sharing at this point in time so you get to see my face, and hello to everyone. The I'm going to give a little ground rules here. If you do want to talk to me, all you got to do is electronically raise your hand. I see that there's already 9 people that have raised their hands. I'm going to try to get to everybody. Please keep your questions succinct and short so that we can get to everybody. Please do not comment on an existing case that you have with my law firm. If you want to do that, please just call me at the office and I'll be happy to talk to you about it. Also, of course, these Zoom broadcasts are for informational purposes only. They're not intended for legal advice. If you do need legal advice, please avail yourself of an attorney. We're going to open it up today to our first meeting participant, and that's going to be Crystal. Crystal, I'm going to ask you to unmute yourself and please ask your question, young lady.
Hi, Dennis. Thank you for doing this. My question is, I have a tenant, a Section 8 tenant in a single family home, city of Los Angeles. It's the only house on the lot. Last week I posted the tenant protection notice as well as the notice that it's exempt from RSO. I want to raise the rent more than 10%, and I understand that that has to be a 90-day notice. My question is, since it's Section 8 and they have to quote unquote approve it, if I were to post a notice, let's just say Monday, that says the new rent is $3,000, but Section 8 says we're only going to give you $2,800, do I have to resubmit a new 90-day notice, or how does that really work? Are they going to say that notice was defective, or?
Okay, so with regard to the Section 8, if Section 8 is, you've agreed to go with Section 8. So if you agree to go with Section 8, then what happens is you are required to accept the rent that they approve. And you can't go above that. It has to be with permission with Section 8. But since you are a single family residence, what you could do if you're unhappy is you can say, since Mr. Section 8, you're not giving me the rent that I think is fair, I can terminate that tenancy with a 90-day notice. And in that basis, the tenant can either accept the rent that you want to charge, but you're not going to be any longer on Section 8, okay?
Okay, so like what happens if I'm okay with the $200 less? Do I have to give them a new 90-day notice that says this is the actual amount, or how does that work?
No, what you're going to do is you're going to terminate the tenancy of the Section 8 tenant on the basis of economic reasons, that I'm not getting the rent that I want. And this is not subject to rent control, okay? So on that basis, you have the right to ask that tenant to move.
But I'm saying I'm okay with it. Let's just say I'm okay with the 2,800.
Okay, then you don't have, then it's Section 8 sets the rent. So they're going to give notice to your tenant what the rent is. You don't have to do a 90-day notice.
Okay, and I'm curious, let's just say I posted these notices, the tenant tears them down or takes them off the building. How liable I am if the tenant keeps, do I have to keep
You're
posting this
not
stuff, or?
liable at all. Just put them up. You took a picture. That's it. If the tenant wants to tear it down, so be it. Anyway,
Okay,
thank you very much,
thank
Crystal.
you.
We're going to move on to let's move on to Nathan. I'm going to ask Nathan to unmute himself. Hello, Nathan.
Hi, Dennis. Thank you so much for what you do and for taking time out of your Saturday to do this. My question, so it's a multifamily apartment building in Westwood, rent controlled. Essentially, the tenant on the top floor has a large outdoor patio, which is bigger than a balcony. It's like the whole floor plan of the building. It's a big patio, and we recently had some leaks that are affecting the floor right below it. So we're now going and making repairs, and we've notified the tenant, and he's fine with that. But he's a lawyer himself. He's like a sports attorney or something. So he's been writing us saying there needs to be rent abatement, and my covenant of quiet enjoyment is being interfered with, and so on and so forth. So just kind of want to get your perspective on, just maybe the legal answer, and then I think the business answer would be, okay, give him a few percent off his rent, because again, like you mentioned at the beginning of the call, he was quite a successful attorney. And I mean, he took full advantage of the COVID rent moratorium, was not paying rent. Any chance he kind of gets, he's quite opportunistic. So
Okay, let me slow
just
you
kind of
down
wanted
because
your
we're,
take on.
yeah, let me slow you down,
Sure,
Nathan, because I've got some questions. Number one, this is in the city of Los Angeles.
sure.
Okay, so as to that COVID
Yes, sir,
rent,
in
as I
Westwood.
just, thank you, as to that COVID rent that I just put up that chart, if he hasn't paid you back, we can start an eviction on him just based on that COVID rent that's due at this moment in time. That's number one. Number two, is it his patio or is it someone else's patio that's leaking?
It is, so it's the roof that's leaking that's hurting the tenant right below
Okay, so
me,
it's from the
beginning
roof, it's
at
going
his
down to his
patio.
patio, correct? Is that
The
correct?
roof is his patio. So it's like the roof is his patio. It's like excuse me,
Got it.
sorry, my laundry machine going off in the back. Yeah, the roof is his patio. It's not a separate thing.
Okay.
He has the whole roof as his balcony.
Gotcha. So, there used to be a show on ABC. It was called Extreme House Makeover, Nathan. You might have seen it. And what they would do is they would pick some family and then they would send them off to Disneyland for a week and they would come back and they'd have a brand new house. It was unbelievable. I don't know if you ever saw
Right.
that show. Did you?
I have. Yep. I
Okay.
have.
So I'm asking you, how the hell long does it take for you to fix this roof slash patio? Get it fixed. What's the problem?
Yeah. I mean, it's going to take 1 month, about a month because of the
Okay, so
rain. We
listen,
can't work when it's raining.
remember Extreme House Makeover? It was 1 week, remember? So get this,
Uh-huh.
look, a landlord does not warrant that nothing will ever go wrong with their property, okay? What a
Hmm.
landlord warrants is that if something is wrong with the unit or the patio, whatever, that the landlord will fix it in a reasonable period of time. So if you're telling me
Sure.
that this job cannot get done, that it's going to take a whole month, somehow I would doubt that. But notwithstanding that, if you need to give him a little bit off the rent, then do so to placate him, as you're saying from a practical business point of view. But I would probably double down on two things. Number one, fixing the problem. You take your car
Hmm.
in, you get it fixed. And the second thing is once it's fixed, I would immediately start going after him for the COVID rent. Okay. Anyway, I think that
Got it.
answered your question, my friend. I'm going to mute you. And I
Thank
think
you.
somebody's playing games here, and I'm not sure how that's happening, but appreciate that you could act like a human being. And let's see. Let's go to Eric S. I'm going to ask you to unmute yourself.
Hi, Dennis. How are you?
I am fine, thank you.
Yes, I asked a question last week about the 30-day notice requirement, and that I know you had needed some time to read up on that law. Um, would I need to reissue a new notice if I gave my tenant the wrong notice for that period
Well,
of time?
if you gave a 30-day notice to pay rent or quit, you don't have to reissue it because you were actually giving more time than what the law requires based on that latest ruling by a judge which struck down the county law that says you have to do a 30-day notice to pay rent or quit. So you can either keep that, which I probably would
Well,
recommend keeping it at this point in
well,
time.
well, I gave a 3-day, not a 30-day
Okay,
for
if
that
you
period. Yeah.
if you gave a 3-day, I'd probably serve a new 3-day after
Okay.
since that ruling came down, which was a writ of mandate ordering the county of Los Angeles not to require for cities in the county to serve a 30-day notice for certain periods of rent that was owed. So I would serve another 3-day notice. It's only 3 days, and then we can proceed forward with the eviction. Okay?
Okay. Yeah.
Uh,
One other question. One other
sure.
question is, what was the question? So I had another case back in October where I prepared a 3-day notice and come to find out it was incorrectly prepared and I lost the case in January. When I issue a new 3-day notice now, since it was only for the month of October, could I ask for October, November, December, and January in the new notice
Of
or just
course,
October?
the fact that you
Okay.
lost on a technicality doesn't mean that you waived the rent and that it flew out the window. You lost on a
Okay.
technicality, you get to redo it again. Anyway,
Okay.
I'm gonna say goodbye to you, Eric, and I'm gonna move on to Iris Prasad. I'm gonna ask you to unmute yourself.
Hi,
Hello,
Dennis.
Iris.
Thank you
Hi.
for doing this.
No problem.
I'll try to be as brief as possible. I have 3 units in a rent-controlled area. I used to live in the house that was in the property. It is a 3-bedroom, 2-bath house. My husband and I moved in 2021, and we rented the master bedroom, which has a bathroom and another bedroom, to a friend of ours. And we kept my son's bedroom for us and for my son when he comes back from college. I recently filed a declaration of intent to evict for landlord occupancy because I want to move back into the house. And the person who's handling the case, she told me that I could not legally rent those 2 rooms, that I could only rent the entire house. So that could be a problem if I had to file an unlawful detainer.
Okay, well, first of all, you're telling me you just had friends of yours that rented most of the house, but you also just retained 1 bedroom for your son to move in, correct?
Yes,
I
for
don't
my
see that.
son.
I don't see that as a problem at all. And now you want to take back the whole house, so you'll be occupying the whole house. There's nothing wrong with that. If you do have to file an unlawful detainer, that would not be in any way any kind of a defense on that issue.
Okay. Oh, so one thing she told me is I had to now, which I believe I'm doing, LARSO. I had to register with LARSO. Is LARSO the rent stabilization ordinance certificate that we get, that we pay $320?
Well, this is a single family home, correct?
No, this is in a 3 unit property. So
Okay.
the single family home is in the front, and I have 2 apartments in the rear.
Yeah, they all have to be registered with the Los Angeles Rent Stabilization Ordinance.
And I do.
Then you'll get a certificate every year. You're not going to be able to proceed forward with an owner move-in if you don't have it registered.
Okay, so just have me renting 2 separate rooms will not preclude me from proceeding and taking back my house.
You can easily get back your house, darling.
Okay, well, thank you.
All right.
Thank you so much.
We're going to move on to M. Brosar. So I'm going to ask you to unmute yourself.
Hey, Dennis, thank you so much. I'm actually Iris's brother. I got an issue myself with a renter. I have a single family home that I'm renting. I'm looking to take that property back because I'm going to be selling the current home that I'm living in. So my question is, do I need to file like my sister did with Larso, for a single family home? I'm not under rent control. I'm in LA County.
Well, you say
And-
LA County, but what city?
Silmar.
Okay, Silmar is the city of Los Angeles.
Okay.
And every residential property now comes under just cause eviction. So while you're not under, quote, LARSO, the rent stabilization ordinance, you are under their just cause ordinance. And you do have to you do have to file this application with the city that you want to move back into that unit. If this is a single family home, the relocation is only 1 month, but you still have to go forward and file that documentation with the city, which of course our firm can assist you with.
Right. Okay. Well, thank you so much. I think that was so no Larso. I don't have to worry about that.
No Larso, my friend. All right,
Okay.
you take
Thank
care,
you.
sir. Okay, so now we're going to move over to Mr. Pai, P-A-I. I'm going to ask you to unmute yourself. There you
Hello,
go.
Dennis.
Hello.
Hi. First of all, thank you for doing what you're doing. I think it helps a lot of us in terms of being informed and educated. I have a couple questions. My first question is, one of my tenants is asking about prepaid rent. I was wondering, is there any rules or limitations regarding that? I just want to make sure I'm doing it right.
I don't think I understand the question. First of all, what city is the property located in?
This one is particular in downtown LA.
Yeah, okay, so the city of Los Angeles, is this an apartment or a house?
7 unit apartment.
7 units. Okay,
Right. I
and
just
you're
wondering about.
asking a
Okay.
question about collecting rent or paying rent. I'm not
Oh,
following the question.
actually, one of my tenants was asking if he could like basically give me a check for, let's say, 6 months rent in advance, like for prepaid rent.
Oh, I see what you're saying. Okay, that's no problem.
Right.
There's an unusual law in the state of California that says a landlord can accept advance rent payments, but it has to be anywhere from 6 months to 1 year in advance. So by
Oh,
doing
okay.
that, you are in accordance with the law. You can't take 5 months, you can't take 4 months, but you can take anywhere from 6 to 8 months on that. Okay?
Yeah. I just took a guess in the dark because I kind of mentioned like, okay, I think we could take up to, I think we take 6 months, but I wasn't sure. So you can say, so he's saying 6 months to 12 months. Okay, that's
You
great.
you got it.
And my other quick question is, I heard that there's like a justice for cause proposition coming up because I'm getting my voting ballot in already. I know that's going to come in November, but besides
It's
telling other
called
people not
justice for tenants. Make sure you
just
vote
tenants,
no on that.
right?
What they're trying to do is to take away the Costa-Hawkins bill, which means that cities could actually regulate when a tenant vacates, what you can charge for the next tenant coming in. It is insane. So
Is
what you need to do is to make sure that you vote no on that justice for tenants. What it is, it's a death threat to landlords. Anyway, thank you very much. I'm going to
thank you very
call on
much.
now Christine Doran, if I'm going to ask you to unmute yourself, if you'd be so kind.
There, does that work?
Yes.
Okay. I just drew up a new lease for a unit in Burbank, and I used your new January 2024 lease. And I saw that you had something on there that says the tenant agrees to waive the right to have any matter settled by a jury trial. Can I use that for a rent control department as well?
Okay, well, let me explain something. In the city of Los Angeles, excuse me, in the state of California, every litigant has the right to ask for a jury trial. So it really doesn't make a difference what you're doing, okay? You have the right to ask for a jury trial. So why do I have that in my rental agreement? And the answer is I have that in my rental agreement because I'm hoping that it dissuades people from asking for jury trials. So if someone would see that and then say, oh, I can't have one, I don't know how much good it does, but I do put it in there, and maybe they'll change the law one day, but that's what the Constitution of the state of California states.
Okay. All right. That answers my question.
All
Thank
right, you take care, okay? And now we're going to move on to DC. I'm going to ask you to unmute yourself if you'd be so kind.
Right.
Hi.
Hi, Dennis. Okay, a question that I have is, do we have to provide a lease in Spanish at any time under any circumstance?
No, you can negotiate in the English language and just use an English rental agreement. I don't recommend ever doing a Spanish rental agreement or a rental agreement in any other language, because if you do, then under California law, you have to serve every notice in that language. So if your tenant doesn't speak English, advise them that they need to get a translator. You only speak the English language, and you should only use English documents.
Oh, okay. And if I am negotiating with them in Spanish, as far as I can give them the lease in English, that's the only one I have. And I can just tell them, have your translator translate it for you if you wish.
Well,
But
I
as
would
far as
not.
showing it,
I would
I mean-
not converse or negotiate with the tenant in
in any other language.
but English. So because you're just going to get yourself into a problem there, and then we're going to start a lawsuit, and we didn't serve a 3-day notice in Spanish, and we can lose the case. So just negotiate it in English. Let them bring a translator, and every document's in English from that point forward.
Oh, okay.
All right. All right. Thank you very much. We're going to call on Michael Ansari. I'm going to ask you to unmute yourself, sir.
Hello,
Michael?
Dennis. Michael
Hello.
Ansari, California Golden Rock Realty and Management.
Well, thank you for that plug. What was that again? Let me hear it again.
Yeah, Michael Ansari at Cali from, I'm I have my company is California Golden Rock Realty and Management. I am
Golden, what was it? One more time?
California Golden Rock Realty
Perfect.
and
Okay, everybody
Management.
write that down. If you need a management company, Michael's going to help you. But anyway, Michael, and you know he's smart because he's asking for my legal advice. So, Michael, what's your question?
Yes, so I'm new in Zoom and also I'm new with your company. Thank you. You did a great job. Your system is like a machine. I don't have to call anybody. I get information as soon as you have it. So thank you. So I have, we have about 30, 40, 50 properties we manage. I have 3 questions from 3 properties. They're all supposed to be easy for you, but for me, hopefully, I learn from you. So we have one property in Reseda, prestigious city of Reseda. It's a single family home, 3-bedroom, 1 bath. And the owner, which is a family trust, they want to sell the place. How do we approach this tenant who is also behind rent for 3 months?
Okay, well, first of all, if a tenant, okay. The concept of having a tenant, okay, is for you to get your rent. If you don't get your rent, there's no reason to have a tenant. So regardless of I want to sell the property and how do I handle this, my good friend, the whole essence of the relationship is you getting your rent. If this guy owes you 3 months rent, okay, then we need to immediately start an eviction based on non-payment of rent, and we'll evict them straight away. Now, if the tenant was paying the rent, so nothing is owed, can you ask a tenant to move in the city of Los Angeles, even though it's a single family home, not subject to rent control? Can you ask him to move because you want to sell the property? And the answer is no. You need just cause to do an eviction or to terminate a tenancy, and that's not considered good cause. But you, my friend, have the best situation. The guy owes you rent. Let's start an eviction based on non-payment of rent, and then that will solve your problem. You'll get rid of him. Then you can obviously prep the premises for sale and sell it.
What if he pays the money that he owes?
Well,
within the
first
3
of all,
days?
right now he owes 3 months rent. I don't think that's going to happen, but let's pretend it did. You still don't have the right to ask him to move just because you're selling the property. But another way to handle that would be you can raise the rent because you're a single family home. So you could raise the rent and he'll probably want to get out at that point in time, or he'll stop paying the rent. You can also do what they call a major renovation, since this is a single family home and not subject to the rent stabilization ordinance. So you have options there, but you don't even have to get to that, my friend. 3 months. How long are we going to wait for this? It would be okay if this tenant was your child, but unless it's your child, then we just need to move forward with it.
Okay, wonderful. My next question is,
Your next and last question, my friend.
okay, so that's we have a property in Encino. There's a detached ADU in the back and one in front. And can we increase the rent 8.8% each tenant,
Okay,
right?
this is in the city of Los Angeles?
Yes, Encino.
Okay, I presume the ADU was built after 1979, correct?
Yes.
Okay, but is more than 15 years old or less?
It was built in 207.
Oh, you're going to make me do math here. Okay, well, I just did. It's more than 15 years. So it's 8.8% for the ADU. That's an accessory dwelling unit. That's the little house in the back that was constructed after the main house. But the main house, which was probably built prior to 1979, is under RSO, the rent stabilization, and the most you can get for that is 4%. So now both of them would be a 30-day notice. So the front house is 4% under RSO. The rear house, which is not under RSO, but under statewide rent control, is 8.8%.
Okay.
And I thank you for your questions.
Thank you. Thank you so much. I appreciate it.
No problem. We're going to move on to Milan. Milan, I'm going to ask you to unmute yourself if you'd be so kind. Milan, where are you? Well, we're gonna move on from you, young sir. Okay, we gave Milan a chance. One last chance. Nope, I think we lost him. Maybe he's sleeping. No problem. I'm gonna ask David Arzon to unmute themselves. David, are you there, young sir?
Yes, sir. How are you today?
You know what? I can't complain.
Good, good. Thank you for your service. You know, I used your firm before for a unlawful detainer. I went to trial with it, had a very good result. You guys were great, and I ended up actually collecting all the money that was due and owing. So thank you for that.
You're very kind.
Um,
Thank you for the words.
Sure. So my current situation is I own a single family home and a standard lease with a clause that provides that no pets are allowed on the property. And that was fine for a substantial length of time. And then I recently discovered that the tenant went ahead and got a dog without my knowledge or consent. So there's still time on the lease. I believe they're in violation of the lease. What are my options at this point?
Again, what city is this?
Calabasas.
Calabasas. It's a beautiful city because I'm sitting in Calabasas as we speak. But notwithstanding, in that situation, you would serve a 3-day notice to perform or quit, giving your tenant 3 days to get rid of the dog. If the tenant doesn't, then you have the right to bring forth an eviction to have them vacate the unit. I don't know if that makes sense to you economically, but if it does, that's one option that you have.
Very well. Thank you.
Okay, David, you take care. We're
Bye
going to
now, you
move
too.
on to Audrey Smith. Audrey Smith, I'm going to ask you to unmute yourself if you'd be so kind.
Yes, hello, how are you?
Audrey, look at you.
And thank you for having these sessions.
Well, I enjoy doing them.
So my question is about how many days after the unlawful detainer is served does the tenant have to respond to it in the city of LA?
Well, the city of LA is irrelevant. It's for the state of California. And in general, if you personally hand it to the tenant's going to have 5 business days to answer the lawsuit if you personally hand it to them. But if you're dealing with 2 tenants and you only can serve one, that's going to be what they call a substituted service, and they have 15 business days. Now, every time you file a lawsuit in the state of California, you also want to get what they call prejudgment protection, where people can't jump into the lawsuit at the end of the case and delay it and force you to make a court appearance. So for the way we filed that, we try to get prejudgment protection in every case. So if we personally hand it to the tenant, we're still going to have to wait 10 business days. If in fact we have to make what they call a substituted service, we can't serve everybody personally by sticking it in their hand, then that's going to be 15 business day notice.
This was put on the door.
Well, you can't put a lawsuit on a door, okay? I presume you were talking about a lawsuit, not a notice, correct?
Unlawful detainer, yeah.
Yes. So you can't put an unlawful detainer on the door unless you go and get something called an order to post. So that's a situation where you're trying to serve the tenant.
Yeah.
The tenant either doesn't answer the door or is not home. So
Right.
you've tried for a week. Then what we do is we apply to the court for something called an order to post that
Right.
allows us to serve the tenant by posting it on the door, but it requires a court order. So once the judge signs it, then what's going to happen is we throw it on the door and we also mail one. Now, in that situation, it's 15 business days for the tenant to respond to the court.
Okay, thank you.
You're very welcome. I'm going to go to Norman Lagerquist. I'm going to ask you to unmute yourself if you'd be so kind.
Good afternoon. I served a 60-day notice of termination based on substantial remodel. And the existing, this is in the County of LA, City of Lawndale. And the tenant would like to move back in after the remodel. I'd like to raise the rent. Is there any limitation on raising the rent in that situation?
That's an interesting question. I haven't actually considered that. You're going under AB 1482 statewide rent control, which states that you can ask a tenant to move. I don't think I've come across that, and I know what my instincts are. Don't rent to them, rent to another party at maximum rent. And I'm pretty sure, well, first of all, the tenant has to vacate for more than 30 days. Anyway, the premises to do the work requires that the premises be uninhabitable for 30 days. I would not rent it to them. I'm not sure whether that's a good advice or not, but I just think it's safe advice that do not rent to them, because otherwise it could be considered an illegal rent increase, because we know now that this was a, did you say this was a single family home
That's
or
a
an
condo.
apartment?
Condo.
Oh, okay,
Condominium?
then I take it back. If it's a condo, you can actually have them move back and charge whatever rent you like, but you don't even have to do the renovation to charge whatever you like. If it's a condo, a townhouse, or a single family residence, you have the right to raise the rent to whatever you like. There's no limitations. If it's more than 10%, it's a 90-day notice. If it's 10% or less, then it would be a 30-day notice. So certainly, if you want to do the renovation and have them move back in at whatever rent you want, you certainly have the right to do so.
Okay, thank you.
You're very welcome. I'm going to move on to Greg. Greg, I'm going to ask you to unmute yourself.
Hey, Dennis.
Hello, Greg.
Thanks for everything you're doing for us. I am not a lawyer, so that's why I'm calling up. And, you know, I think some people have called about SB 267. And I was reading it, and it said that, I'm reading it here, it says person's credit history as part of the application process can be prohibited unless you allow them to provide verifiable alternative evidence of a reasonable ability to pay a
Yes.
portion of the rent. That, so does that mean, like, so basically their credit score sucks, and now they need to give me some secondary information that makes me comfortable to rent to them, even though they're probably have bad credit because they haven't paid bills? Can I stand up and say I'm not accepting that because, you know, how are you going to pay for these bills you owe and have to pay for this part of the rent? I'm kind of perplexed.
Well, so is the rest of the modern world when you have politicians that are trying to basically upend income property owners. What you have is, and for the audience, it's saying that normally when you're going to rent to somebody, you're going to screen their credit. So they've now made, and they've also stated that you have to rent to Section 8 tenants. You just can't say, I'm not going to rent to you. But a way that most landlords didn't rent to Section 8 tenants was on the basis that their credit was bad. So I don't care. I'm not discriminating on the basis of Section 8. I have to take you, but your credit's bad, so I'm not going to take you. So now, as of January 1st, there was a new bill that became law, which states that forget his credit history, landlord. All the tenant has to do is show you that he has the ability to pay. So unless you can get rid of him, reject his application on some other ground, maybe the landlord in the other case said, oh, the guy's screaming and yelling all night long, then technically, if he shows you that he has the ability to pay, then you have to take him. Now, I've said this in previous telecasts, based on the city of Los Angeles law, the state of California law, I am recommending now that you only rent pursuant to a month, 2-month tenancy, that you no longer rent on a 1-year lease. It's easier in those situations to ask a tenant to leave if they're not acting in a proper method. Now, I have heard, and I think this has been verified, that Section 8 will not accept a relationship unless the landlord is offering a 1-year lease. So you have to make your policies consistent. That, you know, you heard from Dennis Block that for reasons of terminating tenancies, it's best to have a month-to-month tenancy. So from this point forward, I don't care who walks to my door with an application, I'm letting them know this is only month-to-month. You might want to even put it into your advertisements or stated policies. And I think that's one way to avoid Section 8 tenants.
And so basically, it's a slippery slope if you're going to have them give you information in lieu of their credit score. They can say this proves that I can afford this place, and you could say no, and then they could sue you for discrimination. Is that
No,
kind of what you're saying?
say just the opposite. Please come on in. Just make sure you tell your Section 8 advisor that I'm only renting this on a month-to-month tenancy. So please, when are you starting? And of course,
Okay.
Section 8 will say no. So, you know,
Okay.
play it right. And but again, make this your consistent policy. I'm never
Okay.
going to rent in my buildings. I'm not renting under any 1-year lease, 6-month lease. Forget it. I'm renting month to month. Besides, you know, if you have a 1-year lease and a tenant leaves sooner than the lease term, you're not chasing them for their money anyway. You know, you're just going to say, oh, what the hell? And you're going to move on to the next applicant. So it's only a sword to you. And since Section 8 does not accept tenancies that are at least 1 year, then that's one way to avoid that situation. Anyway,
So
Reed, thank you.
Okay. Thank you.
You have a good day. Let's take a look. Let's move on to Harold. Harold, I'm going to ask you to unmute yourself if you'd be so kind.
Hi, Dennis. So thankful you didn't make it to Mexico this weekend.
Well, I was planning on doing it in the hotel room, but I'm involved in a personal case against an eviction defense firm where I'm suing them. And everybody out there, if you could just give me a few prayers, because it goes to the jury on Monday, and then I'm really going to be free to talk about it. So that's why I couldn't go to Mexico, because the jury is going out. But I'll talk about that, hopefully dancing. But everybody out there, if you have any goodwill to give me, please do it. And because
good.
the jury's going out on Monday. But in any event, Harold, what's your
Okay.
question this week?
Okay. So if I have a pretty decent sized house. Ever since COVID, there's only been one person there, and I'm just paranoid about what LA's doing, constantly changing, evolving. So what I'm wondering is, if I rent out another room, if I do short-term rental, am I automatically considered RSO, or am I still owner occupied single family residence under just cause only?
Well, somebody pointed out last week, actually, no, I heard it on my YouTube channel, that the county has this rule, which I was aware of, that if you're renting out less than 5 rooms, that it's not considered a boarding house. But I don't believe the city of Los Angeles believes that. So if you're in Los Angeles, if you're renting out more than 1 room, you could be fly in the face of RSO, and which means that those tenancies are illegal.
The reason I say that is short-term rental is less than 30 days. And so it's not really a tenant situation.
That's true. You can do that. Then you're right on that. I didn't hear that part of it, but you do have to have a license.
Yes.
From the city of Los Angeles. You're going to be living there too, because you're doing it. So I don't have a problem with that. Just make sure you get it's called a home sharing is the language that the city uses for Los Angeles.
Right.
Make sure you get your home sharing license, and you'll qualify because you're living there.
Right. And so other than that, there's no sense renting out another room, 30 days or more, because now you're automatically an RSO and you're a slave to the system.
I hear you, my friend. All right. Anyway,
Okay.
Thank you very much. And I'm going to move on to Lujan Lord. I'm going to ask you to unmute yourself, Lujan. Asking, there you go.
Hello. Sorry for interrupting you, but I just wanted to say that Michael M. Sorry is calling me.
You know what? I think we're not going to take Lujan, because I feel something coming up with that. So let's get rid of you, and let's move on to Jason. A good try, Lujan. I want you to know it was a good try, but we don't really need your ilk on my show. I'm going to ask Jason to unmute yourself. Hello, Jason.
Hi, Dennis. How are you?
Good.
Thank you so much for doing this.
Yeah, we're getting some little hecklers in here today, but I'm fending them off pretty good, I think. But anyway, Jason, how can I help you?
Yeah, I have a unit in unincorporated Riverside. I rented. I have a new tenant, and within the first week, they brought a pet in, even though it's no pets. and now they're stating it's an emotional support animal.
Well, then, if it's an emotional support animal, the way the law looks at it, then it's not a pet. It's an emotional support animal. But in order to qualify for an emotional support animal, according to the laws of the state of California, they have to give you something in writing, which is prepared by a medical professional. That's somebody with a name and has some letters after their names. It has to have this medical professional's license number. It has to be within the state of California. It has to state that your tenant has a disability and needs the services of a comfort animal or an emotional support animal. And it also has to state that this patient treated with them 30 days prior to receiving this documentation that this is an emotional support animal. But if they have that and they've complied with the law, then there's really nothing you can do.
Shouldn't they have provide this prior to moving in? Because the ad and the lease says no pets. And I
We
feel that this is
understand
their
that, but again,
default.
there's nothing that you can do with that, my friend. This is the morons who run our state, okay?
Okay,
So
thank you so much, Dennis.
very little that you can do with this.
Yes,
We're
you're
gonna-
awesome, by the way.
I appreciate you. We're going to move on to, let's see, let's move on to Van. Van, I'm going to ask you to unmute yourself.
Hi, Dennis.
Hello, Van. Don't hurt me.
I won't hurt you. Thank you for your time. My question is, I'd like to serve a 15-day notice to pay or quit for unpaid COVID rents in the city of Los Angeles. Is that something I can do? Where can I find the form? And do I have to register with the city?
First of all, this is an apartment or a house?
Apartment.
Okay. And was the building built prior to 1979 or after?
Prior.
Okay, so you have a rent control building, so of course you have to register your units with rent stabilization. Do you not do that?
No, register the notice, like a 3-day notice.
Okay. Every time you serve a 3-day notice or a 15-day notice or any notice to terminate a tenancy, you have to send a copy of that to the city with their eviction cover sheet. You can either do it electronically or you can do it by mail, and that information is contained on my website.
Okay. And then I was looking for a 15-day notice to pay or quit on your website.
So you're in that first time period, correct? Like from March 2020 through September 2021, where you're asking for rent for that period?
Yes, and including the next period too.
Okay, so you do need a 15-day notice. No, I do not have that on my website. You have to list each month separately, okay?
Yes.
So each month separately. And then we're having fun here. Let's get rid of that. Maybe I can get rid of that. Hopefully that'll do that. You have to do each month separately. It's where you're writing, for example, March 2020, $1,500 was owed. April 2020, $1,500 was owed. I don't have that on my website. It's something that we do for our clients. Obviously, there's a charge for that.
So would you recommend we just go with you and have you serve?
Well, let me put it to you this way. The tenant's not going to pay, right?
Yes.
So since the tenant's not going to pay and I don't charge more for doing that, then you might as well have us start it from the beginning, because it would be the off chance that the tenant pays the full amount of rent, and that's not going to happen. Okay.
Great point.
All right. So anyway, thank you very much. I'm going to move on to Dev. Dev, I'm going to ask you to unmute yourself. Are you there, Dev? Last chance.
I'm here.
Good. How are you,
Hi,
sir?
Dennis. I had a question regarding ADU on the RSO property. So this would be a 4-unit in Valley Village. So if we were to convert the ADU, would it still fall under RSO on the building if it's a new construction or convert, or how does that work?
Okay, so, well, you converting something? Are you converting like a garage into an ADU?
Yeah, it'd be like a 4-car garage. Yeah.
Is the garage attached to the?
Detached.
Okay, so then that would not be under LA rent control because it's considered new construction.
Even if it was just a conversion?
Well, you're converting a garage, which is not a residence, into
Right.
a residence. So on
Okay.
that basis, it's not going to be subject to RSO. You can, you don't have to register it. And since it's new, you'd be able to raise the rent to whatever you like, at least for the first 15 years. Then you'd be under statewide rent control.
Interesting. Okay. Okay, that's good. And so that would also allow for short-term rental with that, with if it was not RSO.
You got it.
Got it. Okay.
All right.
Thank you. Yeah.
Thank you, sir. I'm going to
Sure.
move on to Donna. Donna, I'm going to ask you to unmute yourself.
Yes, I'm going to do that. And I was going to say about that Lujan Lord, he's putting up videos over a Hitler photo on this thing. He's being very annoying.
Yeah, I'm going to figure that out next week. I thought I had
I'm
that
so
problem
sorry about
figured
that.
out, so
It's causing a
sorry
lot of
about that.
Okay, so anyways, my question is this. We have a single family home in Sylmar. The tenant originally signed several years ago, about 7 years ago, a 1-year lease. After that, they were month to month. But now they moved in their girlfriend and her niece and 2 dogs, and my husband had raised the rent. And this was probably like a couple years back. And then now he wants to move into that home. I know we have to file a declaration of occupancy and then serve them and all that. But here's a question I have. I was reading about the relocation assistance bulletin because I know we'd have to give them 60-day notice plus 1 month's rent. But there was something that popped out about a qualified tenant, something about if they have 1 or more minor dependents, children. Does that affect what we have to pay them?
Is this a single family home?
Yes, it is.
Okay, so it's only 1 month's rent. The relocation.
Okay, regardless if they have kids or not, no kids or anything.
Right.
Because I didn't know if that correlated with our situation or not. So I just
Yeah.
want clarity on that. Okay, and last question I have for you. Someone was telling me, it doesn't pertain to me, but just in general, they have a tenant who told them for their place here also in Sylmar that they were told by the tenant that if a tenant has not been there more than 2 years, they don't have to return the security deposit to the tenant. That doesn't seem right. Is that true?
You always have to return the security deposit itemization to the tenant within 21 days from when they move out the property.
Right.
So if after deducting for things wrong, there's still monies owed to the tenant, or maybe nothing's wrong and the rent's been paid,
Right.
then you have the right to keep that, but you still have to send that notice out within 21 days. There's no such a thing where a tenant's been there 10 years and they get all the security deposit back. And there's no such a thing where the landlord gets to keep the security deposit unless they've done this itemization showing that the security deposit was spent.
Okay, so like if they've been there, say 7 years, like my situation, and because we want to move into the home, we have to give them the whole security deposit back, provided there's nothing wrong with the house once we do the walkthrough.
Right. But you're always allowed to deduct for cleaning. You're allowed to deduct for unusual wear and tear, and you're also allowed to deduct for any rent owed.
Okay, got it. Now I understand it. Okay, thank you so much.
All right, we're going to move on to Q's mom. Q's mom, I'm going to ask you to unmute yourself.
Hi, Dennis.
Hello.
Can you hear me?
I
Hi,
can.
thank you for your time. This is my first time speaking with you, but I've sent you a lot of referrals. I'm also an attorney and I'm also a real estate broker. My first question to you is regarding late fees. Is there a cap on the amount you can raise for late fees? I recently became my father's property manager. He has property in Inglewood, single family residence, and then also a duplex. And I gave the tenants notice. One of the tenants decided to tell me they were going to pay on the 12th, although the rent is due on the 3rd, $100 late fee if it's after. On the 12th, I couldn't find the tenants. They were not calling me back or answering my calls. So I went on your website, got your 3-day notice, served them, and all of a sudden the rent magically appeared the next day. But it wasn't until like the 20th. And I'm just like, that's a long time. So I wanted
Okay.
to know if there's a cap for rent
Okay.
or for late fees.
Under state law, you have to charge a late fee which corresponds to your expenses and to what that means to you, additional accounting expenses, more of your time having to go back and check whether the rent's there or not. And you have to have that specific language in your rental agreement. You just can't say, oh, $50 late charge if the rent is 5 days late. You can't do that in the state of California. You have to have specific language. If you're curious what that language looks like, if you go to my website, evict123.com, and go on to the free form section, take a look at my lease and look at that, what I have in there. You can switch the numbers around, but that language has to be there. Now, the property that you're talking about, is that, what city is that in?
Inglewood.
Okay, so Inglewood has kind of a rent control statute. So I don't think you can change it for existing tenants. You can do it for new tenants moving in.
Okay.
All right.
And my
Go
next
ahead.
question is for the city of LA. I have a client who has full authority in a real estate listing that I acquired. However, it's a probate, so he has full authority with the court. It's a single family residence in the city of LA, and his sister and her husband resides there. They never paid rent, from my understanding. They will not give me access to view the property. And I wanted to know, because I heard someone before me ask about if a tenant or if a person occupying a property is not paying, can you evict them? So by this being in probate and the client has full authority, is that something that your office can handle? Is that cause for an eviction because they want to sell the property?
Okay, first of all, the person who's in, or the persons who are in possession, are not tenants. They're not tenants because they're not paying rent. So the administrator or the executor of the estate has the right to control the property, and we can issue in that case a special notice. It's a 30-day notice under a theory called tenancy at will. So under that theory, we can bring forth an unlawful detainer action, serving in them with a 30-day notice. Again, we're not under any tenant protection because these people aren't tenants. And yes, my firm handles those kinds of cases all the time.
Great, I will give them your name and number. Thank you so much for your time.
And thank you. We're going to move on to, it looks like, our share. I'm going to ask you to unmute yourself.
Yeah, hello.
Hello.
Thank you for organizing this for the weekend. Thanks. And my question is, I have to import a car, a BMW M4 to Germany, and I have not paid yet, but the dealer refused to ship the
Let me
car.
stop you here, my friend.
The heckler.
Yeah, let's get rid of you. Thank you very much. And also, let's just also bear with me 1 second. I'm going to report you, and so I don't have to deal with you ever again. Perfect. Let's move on to DJ Jordan. I'm going to ask you to unmute yourself.
Hi, Dennis.
Hello.
Hi, I'm so sorry. My name is May. I'm using my son. He helped me, so he using his name. But my name is May. I have question for you. I'm currently helping my late father. He passed away, so I kind of take over and manage the property. I like to do the maintenance inspection in person, and what I noticed when I coming in, the tenant tend to kind of harass me or rude. So luckily, next to my building, there's a property manager. She speak fluent English and Spanish. So I like to have her accompany me when I come in to do maintenance inspection. So prior to come inside the unit, I did issue a letter explaining to the tenant that now that I have additional person just for translation if need be, or kind of like, help out with the inspection. I gave them the notice, and then the day that I came, they lighting up. There's 7 units. There were just 3 of them light up and like object, saying, you. And then by the way, my property is in LLC. So they object and they say, oh, you shouldn't I'm not comfortable. Have her come in. Only you, but not her. So I want to know what my right as a, an LLC and property manager. Can I have a second person accompany me?
First of all, what city are we talking about?
Huntington Park.
Okay, and is this an apartment or a house?
It's apartment.
Okay.
It is
And
actually like a cottage, little separate house, little house, 7
Gotcha.
units.
Gotcha. And when you wanted to go in, you said for an inspection, what were you going in there for to do?
Man inspection yearly or every 6 months I do smoke detector checks and just check.
Okay, so you can't do in California just an inspection, believe it or not, but you can go in to check the smoke detectors. Your property is held in an LLC, so even if it wasn't, you certainly have the right to have your agent go in there with you. Now, they refused. Did you go in there without the agent, or you just turned around and left?
Actually, so they refused. So then she ended up standing outside, and I came in. But I told them this time I will come in, accommodating just for just by myself. But I'm gonna give you further notice, sort of like give you more time to adjust to this. So that's where I did. My question is, at this time, do I need to issue another letter and let them know, the next?
Why do you need to go in again at this point?
Oh no, I'm just saying every year.
I would issue the next time you do this, tell them that myself and my agent are coming in. If you refuse to allow both people to come in, because listen, I don't have the expertise to know about air conditioners or anything else that needs to be checked. I obviously need to have a workman to come in with me. So on that basis, if you refuse to let me in, that will be grounds for eviction.
Got it.
And hopefully you've raised that rent 8.8% under the statewide law. Did you?
Yes.
Good, because they deserve it.
I have a second question now. This tenant is a partnership. No, partner, I'm sorry, not husband and wife, but they live together. They have kids that 13, 14, and 17 years old. They went through some fighting or separation. They holding the rent hostage, sort of like when they're in a good mood or they get along, then they pay rent. And if they don't get along, then they don't pay rent. They has been going on for about a few months now. I'm thinking of doing an eviction. My question is, because now the guy, he say that, by the way, I don't live there anymore. But I see him coming in and out, depend, like they get along or not. But he claimed that he lives somewhere else. And I do see that he's not there as often as he should be.
Okay, but let me stop you here. Where they're living, how they're doing it, fighting between themselves, totally irrelevant to everything you're talking about. The only thing you care about in life when you own income property is that you get your rent paid, that your building is not being damaged, and that the peace and tranquility of the property is where it's supposed to be so they're not bothering other residents. So you don't have to worry about these all extraneous matters. But right now, if they owe you rent, again, that's the essence of why you have a tenant. There's no reason to have a tenant if they're not paying you rent. So in this situation, I would certainly serve a 3-day notice and proceed forward with an eviction. Ladies and gentlemen, I'm going to call it a day since we're past our 1 hour. And we're going to pick it up next week, 3 p.m. on Saturday. Hopefully I'll have good news on that lawsuit. Everybody pray for me. And for the people that we didn't get to, I'm sorry, but get in earlier next week. And once again, if you do watch this on YouTube, please subscribe to my channel. And with that, I want to say have a great weekend, everybody. And I am off. Take care.